Dimitri Lopez.
All right, so we're seeing you this morning on a few different matters. You've got a case out of Tucson City Court from 2024 with a misdemeanor warrant. You have a felony warrant that was issued in 2025 as to a charge of escape in the second degree from an adult correctional facility. And then you have some new felony charges or a new felony case where you've been charged with theft of means of transportation, burglary in the third degree, possession of a dangerous drug, and possession of drug paraphernalia. Now, sir, you do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney. And for your felony matters, I am going to appoint the public defender's office to represent you. We'll talk about your city court case in a little bit here. Now, I want to start with the new felony case. So in that case, I've read so we can do both of them together. So in both cases, I've read the pretrial services report. I've read the interim complaint for the new case. I don't have much information as to the warrant case, but I have at the very least reviewed the warrant. And I see that the state is asking for a $10,000 bond in the new case and is asking for a $75,000 bond in the warrant case. Mr. Goodman, did you wish to be heard any further?
Yes, Judge, just to give a little more context of the sequence of events, at least from what I've reviewed, what had happened was he was booked into the jail on the interim, I'm assuming, for the theft of means case. And then before he could be seen by a judge, he's essentially goes through the process of being released under another person's identity that was at the jail with a similar name. Was contacted by law enforcement to turn himself in. He failed to do so. He told a family member that he knew or he was wrongfully released and essentially absconded. And that's why the JP court warrant had the issue for the escape case. So based on the sequence of events, the nature of the theft of means, especially on the, I want to say the escape case, that's why the state believes a high bond listed in that JP court warrant is appropriate based on the circumstances.
Ms. Catalizza, did you wish to be heard?
Just briefly, Your Honor. First, I will note both that what Mr. Goodman has described in the Warren case, as well as what we have before the court on the new allegations, both nonviolent offenses. I will just ask the court to recognize that he is 24. He does not have a long history of offenses. And I further take some issue with the third degree charge. To me, just based on the interim complaint, it is unclear what indicates the intent to commit the underlying theft or felony. So I would ask that that be dismissed. I am asking for release in matters. However, if the court is not inclined to do that, given his age, given his indigency, his serious problems, would ask for low bonds in each matter, given that he's unlikely to find out at all.
All right, so as to the motion to dismiss the burglary charge, I am going to deny that at this time. Based on my reading of the affidavit, a car would be considered a structure. To be able to steal the car, it looks like what he did in this case was actually enter that structure to take it. So I do find that there's sufficient probable cause to go forward on that. Now, in terms of release conditions for these cases, in the newer case, I am going to order that he be held on a $10,000 cash or secured bond. You will be supervised by pretrial services, and you are not to possess or consume any alcohol or illegal drugs and possess no firearms or weapons. Now, it looks like in that case, there is a co-defendant who is currently set for a preliminary hearing on April 7th. So I'm going to set that case for the same date. So that will be April the 7th at 1:30 in the afternoon. I'm also going to order that you not have any contact with any of the alleged victims, their residences, or their workplaces. Now, as to the warrant case, in that matter, I am going to order that you be held on a $20,000 cash or secured bond. You will again be supervised by pretrial services, and you will have conditions identical with the exception of the victim contact restrictions as to the other case. Now, in that case, a preliminary hearing is going to be set for April the 9th at 1:30 in the afternoon. Now, in the Tucson City Court matter, in that case, sir, I'm going to order that you be held on a $500 cash or secured bond. I am going to appoint the city public defender's office to represent you. And going back a bit, in case I wasn't clear, on both of your felony matters, I'm appointing the public defender's office to represent you in that. In your city court case, you were not to possess or consume any alcohol or illegal drugs. You were not to have any contact with any alleged victims and not return to the incident location. Now, in addition to the rights I mentioned before, you also have the right to be present for all court proceedings. However, if you fail to show, then a warrant will issue for your arrest, and those hearings can happen without you. Now, if you are convicted and you cannot be sentenced within 90 days because of your failure to appear, you could also lose your right to a direct appeal. Now, in your city court matter, I don't see that you were ever arraigned, so I am going to enter not guilties on your behalf. And I'm going to set your city court matter for a hearing. If you are out of custody, it will be April 18th, 2025 at 1:30 in the afternoon. If you are still in custody, you will be transported for a video review hearing on April the 7th at 1:45 in the afternoon. Now, sir, if you bond out of custody, you have 3 different matters pending in 2 different courthouses. You need to make sure you make it every one of your court appearances. If you don't, a warrant will issue. Do you understand?
Yes.
That's all for this morning, sir. You're excused.